हॅलो. आवाज जाईल तिकडे जाईल बारीक बोलत असतो. आपला आवाज जातो तिकडे.
हॅलो त्रिभुवन सर. ओके ओके. हर्षल हर्षल आपल्यासारखे गरबड लोक आहेत. लॅपटॉप तुझा आहे ना त्याच्यावर तुला त्याच्या
Welcome all the participants. Mostly the participants from the other states, the Sekar Udyam, today's research persons, Dr. Betkar, principal from the Sri Kumarswami Mahavidyalaya Ausa, Latur.
आवाज जरा हे होतोय.
इथे क्लिअर येतोय आवाज.
इकडे डबल दा असं हा इथे तसंच येतो.
युट्यूब बंद आहे. हॅलो. ओके. गुगल मीट कोणाचा बंद आहे. खाली दोन गुगल मीट अकाउंट चाललेत का बच्चा सर? खाली किती गुगल मीट अकाउंट ओपन केले?
एकच आहे.
मग खालून आवाज तुमचा मला येत नाही. बरं ठीक आहे, मी बघतो, चेक करतो कुठे इकडे.
बेटकर सर
ठीक है
बोलता कसं
I request students, please join to YouTube and not to the Google Meet. I request to students, please join to YouTube.
बेटकर सर
हो सर बोलतोय सर
सर व्हेरी नाईस
थँक्यू सर
17. युट्यूबला नाव झाले युट्यूबला नाव दिस आकडा येतो नाही पाठी मागे बोलेन का वेलकम मॅम Hello, Core ma'am. Hello. Are you audible to me? Hello. Yes. Yes. Welcome, Principal Ma'am. Hello. Principal Dr. Yeola Ma'am.
Oh, thank you, sir. Thank you.
Yes, welcome.
Okay, sir. Okay.
So you can directly join on the. त्यांना म्हणा तुम्ही चेक करा, प्रत्येक टाकत ना. टाकलेलं आहे सगळं. कॉलेजच्या ग्रुपवर युट्यूबला पण
वेलकम मॅम. वेलकम.
welcome all the participants.
Yes, yes. Now start. How much? Very nice. Good morning to all. I am Dr. Dhanraj Goswami, Principal of Swami Muktanand College of Yeola. Heartily welcome everyone on the occasion of national level webinar on intellectual property rights and patent filing, arranged by IQAC of Swami Muktanand College, Yeola. Intellectual property rights are legal and institutional devices to protect creation of the mind, such as inventions, work of art and literature, and design. They also include marks on products to indicate their difference from similar ones sold by competitors. IPR is protected in law by patents, copyrights, and trademarks, which enable people to earn recognition on or financial benefit from their invention or research. The IPR system aims to foster an environment in which creativity and innovation. We are graced by their presence on this event that makes this day even more memorable, and golden webinar wouldn't have been possible without kind support and encouragement of Honorable Dr. Amritsar Sarangdhar Pahalwan, President of Sri Gurudev Shikshan Mandal, and Honorable Sri Deepak Bhau Sridhar Gaikwad and other management members. I am honored to welcome our prestigious dignitaries today. Speaker Dr. Betkar M.M, Principal Sri Kumarswami Mahavidyalaya Ausa, District Latur. It gives me immense pleasure to introduce today's topic to all of you. I hope this webinar will be fruitful and informative to you. Thank you, one and all. Thank you.
Thank you, sir. I am audible, sir, please.
Yes.
Thank you. Thank you. In the today's event of National Webinar on Intellectual Property Rights and Patent Filing, Honorable Chairman of Sri Gurudeva Shikshan Prasarak Mandal Yeola, Honorable Amritji Pailwanji, Honorable Secretary Deepak Bahu Gaikwadji, Honorable Director Sanjay Nagdekar sir, Honorable Principal of this college, Pracharya Dr. Dhanraj Goswami sir, invited Honorable Principal Dr. Yamuna ji, she is from first grade college of Karnataka, IQAC Coordinator Professor Sanjay Tribhuwan sir, convener of this webinar and who is having so much efforts of creating links and approaching to all participants, Dr. Sahebrao Dhanwate sir, Professor Srimati Malati Pande, co-convener of this organizing committee, all the participants and the staff of this college. It's my privilege to express sincere thanks to join with you as a resource person on this event of international conference or national webinar on intellectual property rights and patent filing. So college is having initiative with IQAC department to conduct this program not only in the field for not only to file a AQR as an act, but this subject should be understandable or reachable, aware of this subject should be done to our the staff and the participant and the students also. So with this initiative, I welcome to all and congratulate to all organizing team, and I would like to share my knowledge here as I have in the field with a nice introduction of you from this college by me. I would like to share my PPT here. This is Swami Muktanand College of Science, Yeola district, Nashik, Maharashtra. IQAC organizing national webinar on intellectual property rights and patent filing. Today, I am Dr. Betkar M.M, Principal Sri Kumarswami Mahavidyalaya Ausa, joined here as a resource person. What are the objective of my presentation? In next 1 hour, we will go through this to know the intellectual property rights and intellectual properties. What are intellectual properties are defined in India? What are the rights associated with it? We will discuss this one. Also, we will go ahead for knowing the process of filing patents. After knowing IPRs, we would like to go to process of filing patents to know the process of filing patents. And third is to aware on IPRs in humanities stream, because all the science humanities stream teachers may think that this subject is related only with science field students or teachers, but not the case. It's the subject related to all teachers from senior college, junior college, vocational college. All the teachers should take benefit of this. So third objective I have included here, to aware on intellectual property rights in humanities stream also. In next 1 hour, we will go to view the points. What is IPR? What are the types and groups of IPR? What is IPR infringement? What is a patent? What is a patent filing process? What are the useful websites related to patent? What are the examples and what are the news related to the patents and the IPR and the intellectual property benefits, also the scope of intellectual property rights in humanities stream. So this is in all structure of my webinar. So let us we go through one by one slide. Let us see the first slide, which stands with the letter I. What is I? I request organizing committee host to mute. Someone is having unmuted one, please. So letter I. In the word intellectual property rights, first letter is I. First letter I stands for intelligent thinking of a mind. On the screen, a person is thinking. As an example, I have showed that he is thinking to create an electric bulb. So it's a natural thing of a person, it's natural thing of a human being that he or she always thinks. So thinking is, thinking is innovative, and if she gives or thinking gives some idea, that is the intellectual idea. And the person is thinking to create an electric bulb as an example. Now, that person have created an electric bulb now. After thinking to form an electric bulb, so it is now defined as a intellectual property came from intellectual mind. What is intellectual property? It is the property came out from the intellectual thinking of a mind. And what happens? If an intellectual property gets created, some peoples from the society try to stolen their knowledge, try to stolen the existing knowledge, try to use that technology without consent of the author or the inventor. And it's wrong thing. And it happens before the registration of the intellectual property. Sir, mic is unmuted now. Okay, sir. It was because of the streaming. I will close it. Thank you, sir. If there is a problem, please communicate me. So, in the yes, yes, sir. Yes, sir. It is visible now, sir.
Yes.
Thank you. So, after creating a property, some people from the society try to stolen the knowledge, try to use that knowledge without consent of that author or inventor, and it's wrong thing. So we have to exclude, we have to lock such personalities, those not for not using your innovation or technology without your consent. These things happen before the registration of the intellectual property. We have to exclude others. They don't use the property or intellectual property without your consent. So after the registration of that property, we exclude others for using without your consent, and at that time it is defined over the creation. Registration in proper way is important on the name. So the rights, what are the intellectual property rights? The rights given over the creations of mind. After the registration, government gives the right. Let us go ahead. There are two groups of intellectual properties. First is intangible property, where we can't touch, like music, any theme of the book or idea in our mind. This is the intellectual property. Property word is most important because it intangible property, not physical property. And secondly, tangible property means to which we can touch, like motor, car, bikes, all any equipment, which is a tangible property. And these are the two groups of intellectual properties. Now, after seeing the groups, let us see types of intellectual properties available in the India or defined in India. Let us see the first type. First type is a trademark, and trademark is word well known to us. When we buy a product, purchase a product, it is packed with a logo or monogram of that brand. So that is the trademark. And trademark is an intellectual property because before forming a factory or any institution, that company organizers create their own logo, and after creating their own logo symbol, creative symbol, they have to register in the trademark office, and then only they get the right to use for marketing their goods, and no other can use that trademark of their own. Means the trademarks here I have shown as an example: Amul, the Taste of India, Jack Daniel, Nestle, that's Audi, that BMW, that RK Films. I mean, these are very different, and the persons or the organization is free to create their own logo known as a trademark, and they have to register as a intellectual property, so they can get the right using of that and exclude others by for using the same monogram, same logo. This is the first intellectual property. Now let us go to the second intellectual property, that is the geographical indication. The geographical indications, what are these? These are the man-made or natural products which are famous from that area, and if they are registered under the geographical indications, they will be go on the map of the world, and their product economy, product demand goes increasing, and that product is on the map of the world, so that local economy of that market gets increased. And the most benefit is that no one can claim that product is from their area. So the different products as like Nagpur orange, basmati rice, Paitana Paitani, Kullu shal, Nashik Valley wine, Tirupati laddu, all these are the geographical indications of our India and registered under the geographical tag. As our principal was saying that you have a Yeola Paitani and it is copyrighted one. So that's why we have to register our products which are famous in our area under the geographical indication. So these are the famous geographical indications, and India have registered 625 geographical indications up to today, and Karnataka is having highest geographical tags, that is 42 tags. So basmati rice, Kanchipuram silk sari, Kolhapuri chappal, Puneri pagdi, all these are pictures of the geographical tags I have shown here. This is the second intellectual property of the our India, and this is the second intellectual property, that is the geographical indication. As you are knowing that when America have filed the patent on the turmeric, so our India invoked that Mashalkar have revoked that patent from America, because the literature of the turmeric was available in our literature. So no one can claim that geographical indications from that area. Let us go toward the third intellectual property, that is the utility model. What is utility model? It's just a 3D structure of any model that can be registered under the utility model as a third intellectual property. On the screen, you are seeing two pictures. One picture is of the equipment, which is a moving one, and the 3D structure of this is designed under utility model. And second picture is an ornamental picture, means that lady is wearing ornament. And if you visit to the branded Shopee, that PN Gadgil or any Shopee, Pete, all the branded Shopee shops, then if you want to purchase an ornament, if it is having gold of 10 gram included in that, they should charge 60,000. But the registered intellectual property designer, they create a unique design and they register their property as a design model, and it is a unique one. So they charge very large amount, more than 1 lakh, because it is the benefit of the registration of that design, unique design. Nowhere you can find the same design in other shop also. So that is the benefit of design utility model. What is the third intellectual property? It is the just the external features of a model designed under the utility model. Let us see the fourth intellectual property, that is the plant's breeder right. What is plant's breeder right? When a farmer or any agro-industrial or any scientist breeds a new variety of the breed by using the technology, that biotechnology or tissue culture or any cutting technology, any technology. If the breed is new, if the plant is new, then that can be registered under the plant's breeder right. This is the fourth intellectual property. Now, let us go toward the fifth intellectual property. Fifth intellectual property is the copyright. And copyright is a well-known word to us. Every researcher or every writer, or we always see on the book, in the newspaper article, or any or research paper published, or any painting, audio CD, video CD, software, all are copywritten one. And copyright is allowed, given to such creations of audio, video, painting, book, drama, video. All these things have applied for copyright, means they are having copyright. And copyright right is a universal right, means other intellectual property rights are limited to some area or geographical area of that country, but copyright is the universal right. If you write any book and it is going to purchase or going to sell in other country, Pakistan or USA or any other country, then you get the right of that copyright. So copyright is a universal right, and it's the famous right one, which is known to all, and it applicable after the publication of that creation. There is no need to apply separately for a copyright. Now, sixth intellectual property is the semiconductor IC layout design. Since you are knowing that all the ICs are having unique structure, they are functioning uniquely, and they are having innovative nature, design nature, so they can be registered under the semiconductor IC layout design as the sixth intellectual property. And that property, that IC use based the equipments, can be patented. Now, let us see the seventh intellectual property, that is the patent. The main thing is that we more emphasize on this patent section. Let us go ahead for defining the patent. What is patent? It is a monopoly right granted to a person, means it is a right, monopoly right, स्वामित्वाचा अधिकार, एकस्वाता अधिकार, so one monopoly right granted to a person. Who grants the right? Government grants the right. To whom? Who has invented a new, novel and useful article. Means if someone have invented new, novel and useful article, then rights are given to that person, are known as the patent right. Secondly, it may be improvement of an existing article. Let us explain more. What is improvement? You are seeing that just their car are running now on the electric one. Before that, it was running on CNG, petrol, diesel, and all the fuels. These like fuels are used by the car. So at every time, that car engine was developed. Means article is same car, but the engine is improved. So that improvement of an existing article can give or can be defined as a patent. Thirdly, a new process of making an article. If article is same, but process of making is different, then it can be defined as a patent. For an example, let us see paracetamol tablets. If paracetamol tablet is same article, but it is synthesized by various companies. So every company is having its own synthesis process. So that new process can be granted as a patent or defined as a patent. And important thing is that it should be used in the industrial capable application. Mean there is no any patent of the imaginary things. So what is patent? It is a monopoly right granted to a person who invented a new novel article, useful article, or it may be improvement of an existing article, or it may be new process of making an article. Three things are required for filing a patent. First, there should be novelty, there should be inventiveness, and there must be utility. If three things are satisfied in an innovation, then it can be defined or granted for the patent. Now, after seeing the definition of the patent, let us go ahead for knowing patentable inventions. Means all inventions are not patentable, so that we just see the patentable invention. Because if you file a patent or if you think to file a patent, if it is not patentable, then our exertion goes into waste. So that let us see the patentable inventions. Firstly, any machine, apparatus, other articles, invention depend upon the machines, apparatus, other articles which are innovative one, they can be granted for the patent. Any machines, apparatus, innovative articles can be granted for the patent. Secondly, the process or method of synthesis, if it is innovative one, it can be granted for the patent. Thirdly, software which is used with the hardware. Software which is used the hardware means single software cannot be granted for the patent, but if the software is used to run any hardware, that software can be granted with the patent with that hardware. Now, the food products, chemicals and machines, medicines and drugs are granted for the patent. Why medicines and drugs and why granted for the patent? Because if you mix some chemicals together, they react in between, and all chemicals lose their original property, and they reacted in between, giving a new innovative product, that is medicine or drug. So these can be granted for the patent. Medicines, drugs, chemicals, food products are granted for the patent. Now, non-patentable invention. After seeing the patentable invention, it's must to know the non-patentable inventions. What are the non-patentable inventions? Firstly, known inventions are not applied for the patent. The knowledge which is existing in the nature, existing in the literature, not applied for the patent, so that no inventions cannot be granted applied for the patent. Secondly, the inventions contrary to natural laws, those are contrary to natural laws, are violating the natural laws, the all invent on this are not patentable. Thirdly, the inventions depends upon the objective of causing the against the public's ethics and morality. If there is against public's and ethics morality objective, that cannot be granted for the patent. Fourth, the commercial exploitation. Those machines are having based the objective on the commercial exploitation, they cannot be granted for the patent. Number fifth, the equipments which are harmful to human, animal, plant life or environment. The equipments which are created having objective, those can be harmful to health of human, health of animal, health of plant life or to the environment. They cannot be granted for the patent. Number six, the discovery of the scientific principle cannot be granted for the patent. It cannot be equipped, and this is well known to all. Since number seventh, objective of substance objective obtained by just admixture. What is admixture? Chemical field students or teachers may know very nice. What is admixture? Admixture is a mixture, not reacted. So that mixture is known as the admixture. That may be liquid, and that cannot be granted for the patent, because as a definition, there should be a new innovative product and there should be chemical reaction in between gradient. So at that time, admixtures are not reacted in between, and it cannot be granted for the patent. If you give an example of the lemon juice the admixture, the sugar, salt, water, lemon juice, all these are the admixtures. They are just give a various flavor, but not they have reacted in between. So admixtures cannot be granted for the patent. And number 8, plant and animals in whole or any part cannot be granted for the patent, because they born naturally, they are growing naturally. So plants and animals we cannot claim for the patent, or any part or any whole or any part we cannot grant applied for the patent. And the method of medical cure cannot be granted for the patent. Method of medical cure. I am saying that method of medical cure, just a cure method without any equipment. So that can be granted, that cannot be applied for the patent, but the equipments used in medical sector can be applied for the patent. As like Nadi Pariksha, that physiotherapy, that therapy which is just for curing without equipment, that cannot be granted for the patent. And method of agriculture or horticulture cultivation, means method of agriculture and horticulture cultivation method is free from applying for the grant, but the equipments used in the medical field or the agriculture field are applied for the patent. And the traditional knowledge, 11th thing, traditional knowledge is not applied for the patent. The knowledge is came towards from the first generation to the second generation and will go toward the next generation. So traditional knowledge is well known to us, it cannot be granted for the patent. Number 12, atomic energy inventions cannot be granted for the patent for a common man. If you want to file a patent of atomic energy, you have to apply for the atomic energy division of the government of India. If they get permitted, then you can apply for the patent in the atomic energy. And after seeing what is patentable, after seeing what is non-patentable, let us see few simple examples on the patent. These are the very simple examples I have collected here. First is the anti-itching face mask. It is applied for the patent and granted for the patent. Just it is a locking system to a patient, not to eat in between without the recommend of a doctor. So it is a just anti-itching face mask applied for the patent and granted for the patent. Secondly, it is a patent on back scratching. It's the natural thing that one should take help for curing the back scratching, but if there is equipment, it can be used for this, and this is a simple equipment applied for the patent known as the patent on back scratching. Now, this is the third example I have quoted here. It is the example of curing headache released at work. Means someone is not able to do some work, then this treatment is given by that officer, and this is the simple patent granted by the authority for the invention curing headache released at work. Now, after seeing what is patentable, what is non-patentable with the examples of the patents, let us see 1 to 4. What is 1 to 4? 1 to 4 is the how one invention, how one intellectual property is related to other intellectual properties. Let us see on the screen. There is a digital FM tuner, just a portable digital audio player or video player created by the formed by the company Philips. So the invention is patented. It's a 3D design which you are seeing here. Locking system, switches, forward, reverse, all these switches. All these are external designs, thickness, width, shape. It is registered under the design, and the name Philips is designed under the trademark, registered under the trademark. And the audio and video you are seeing and watching, it is registered under the copyright. So one invention is related to other things also, as like patent, design, trademark, and copyright. If you not given the name trademark here for this equipment, then one can stolen this and fix his or her symbol that factory, and then it will sell by the other companies also. So we have to register its design, trademark, and copyright also for using that, for enjoying the rights related to intellectual properties. Now, let us see, can we patent coronavirus? Means coronavirus is observed and it is having a pandemic throughout the world. So you might be having question in your mind that can coronavirus be patented? By law, we just give an answer of it. Coronavirus is not patented because it is not new. Those things which are new, they can be patented. Why it is not new? Coronavirus is found in the literature of the zoology and medicine literature. in 1962. So coronavirus is not patented. And second thing is that we cannot file a patent on a naturally born thing. So corona is naturally born and it is the virus. So we can't patent on the coronavirus. It's just an extra discussion in this case because we are here running because of the coronavirus. We are running the webinars or online education activities. So there may be a question in your mind why this coronavirus is not patented. I have given the answer of it. Now, after seeing the details of the patents, examples, and what is to be patented, what is not to be patentable. So let us we go toward the filing of the patent. How patents are filed? How we file a patent? Let us go ahead in this section. So first of all, if you want to file a patent, you have to write the idea as much detail as possible. Means you have to write every aspect of that idea, maybe in rough, but you have to write the detail about it. And secondly, if you found that it is a patentable subject matter, then you can go ahead for filing the patent. If you have written so much and if it is not patentable, then your exertion goes into waste. So second thing is that we have to check the patentability of this subject matter, and if you confirm that it is patentable, it is a name to you and your institute, then you can go ahead for filing the patent by process. So it's must to see, write the idea detail as possible, and you have to check the patentability of that subject matter. Now, there are again three steps. First step is searching, second step is drafting, and third step is sending. So these three things are steps are useful for filing a patent. So let us see one by one the detail about it. What is first step? Searching. Searching means as like we search the related literature on the website for writing our thesis or publishing our research paper. Similarly, if you want to file a patent, we have to search the most related patents available in the website, and you have to refer that patent, and you have to say that how your patent is different, modified, innovated from such existing patent. So it's the first step in searching of the patent in the universal database. So what are the search engines? The 5 search engines are sufficient for filing a patent, for granting a patent. First is the Google patent. It is the first search engine, Google patent. Second, USPTO patent, full text and image database search. Third is the Indian INPAS patent, advanced patent search system. And fourth is the ESPC net. And fifth is the WIPO, World Intellectual Property Organization. If you visit these websites, you may get lakhs of patents available, and you have to search most related patents to your invention. So it's must to search on the search engine before filing a patent. This is the searching process. And second, let us here, I would like to give an example here, a screenshot of my searching. I have searched an example of PEN. So pen is having more than 2 lakhs patents. The useful pen, which is we are daily using, it is modified or innovated more than 2 lakhs times. So pen is having patent more than 2 lakh times. It's the benefit of searching that you have to relate your patent with the existing patent, and you have to share how it is improved, how it is modified to your patent. Second step is drafting. Drafting is also important because we have to draft our patent in a techno-legal language. As like our court matter cases, if you read something, it is having its own specific language. That may be Hindi or English, but we have to write the patent in the patent's techno-legal language properly. That is the drafting. As we draft our research paper, abstract title, author's name, abstract, then the introduction, the research methodology, calculations, characterizations, and conclusion. So it's the structure of our research paper. Similarly, there is structure of the patent database, and we have to write the patent in the proper format, in the proper language. Thirdly, after searching, after drafting the patent, we have to send our patent. we have to send our patent, and we can send our patent by two ways. On the screen, if you are seeing that there are two methods I have given. First is manual and second is the e-sending. From picture, it's very clear that for manual sending, we have to download the form, fill up the form, and get a DD from the bank and go to the courier or post office, and we have to send our patent. This is the first process. Second is the e-sending. What is e-sending? Just without going away from the home, you can file the patent from home by going to visit the website http ipindia.government.online e-patent filing. So this method can be used to all, and it is very easy one. We have to pay the fees through online mode also. So it the second type of e-filing is easy than the first filing. So there are two types of sending methods. Now, there may be question in your mind that where to file our patent. We have to file, we can file the patent in one of the offices of the Government of India, that is Mumbai, Chennai, New Delhi or Kolkata. But all offices are having their judicial area. If our address falls in that judicial area, we can file the patent in that office. I mean, there is no any difference between filing anywhere, but all patents are processed under one roof by the patent office. So it's the provision to approach that office for that particular person. So from the Maharashtra, if you want to file the patent, we can file the patent in Mumbai office, and other offices are from the other judicial area. So you can file the patent in Mumbai office. Now, after the submission offices, let us we go to the section patent filing forms and fees. So it might be question in your mind that which forms are required, how much fees is having for the patent, for filing a patent. Let us we answer these questions of your mind. There are four forms required for filing a patent. There are number of forms, but having different objectives. But in general, four forms are required for filing a patent. Form number one, form number two, form number 9, and form number 18. These are nominations done by the patent office, not by me. Number one is patent application for the patent, which is having fees of 1,600. Second is the complete specification, no fee करतो. So if you file the provisionally, you can go ahead for complete filing. It's a natural process. So there are two types, just provisional and complete. Provisional file gives just the registration of title, and no one can file the patent on the same title. Is the benefit of provisional submission. After the provisional submission, let us see the tenure of intellectual properties. This is the important thing, is that once if you granted a patent, it cannot be enjoyed throughout the life, but it can be enjoyed for particular time tenure. Let us see what are the tenures of the patents. Patent is having tenure of 20 years, copyright 70 years, and up to the life of that person. Designing 15 years, plants builder right 15 years. So this is the tenure of the patent. But if you renew the patent, then tenure is applicable. If you not renew that patent within that time, then it cannot be applied further, means it cannot be extended. And no copyright, no patent, no design is extended beyond this above limit. So it is the ceiling. And after that, that knowledge is given, that knowledge is free to all, and no one can claim the rights after the tenure. But the trademark is having 10-year tenure, but it can be renewed after 10 years infinite times. Means trademark is only renewable after infinite times, because at every time the purchaser or the goods product, if you see on the trademark, which is having 100 or 20 years back, the same trademark is used by the factories, because it's the brand name and it cannot be changed. It is the faith name of the consumers. So that trademarks can be renewed after 10 years. So that's why the factories are using more than 100 and 200 years the same trademark. Now, I would like to share one thing, is that our Maharashtra is leading for filing a patent, and Maharashtra have filed more than 300, means nearly 400,000 patents in the year of 17 to 80. This data is collected by the Patent Office, Government of India. So it's a proud thing is that Maharashtra is more aware in filing the patent. Now, about the rights of the patents. So patents right as territorial rights. The meaning is that if you file a patent in India, our rights are only applicable in India. If someone is selling or duplicating that product using that technology in other countries or out of our India, we can't do that. So patents rights are territorial rights. But if you file an international patent through India, then because of the Government India facility, the patent goes to the more than 50 countries. This is the procedure by the Government of India given to all researchers to file a patent internationally, and you can get right more than 50 countries when you file internationally that patent, because of that commitment of the Government India with the other countries. Now, let us see what we can do with IPR. What is IPR? It's the intellectual property. It's only the certificate, not the physical property. But the every rule, every law is applied as like physical property to the intellectual property. Let us see these three things. First, IPR can be assigned. Means we can assign the IPR as like we can assign our physical property for few years for financial benefit. So IPR certificate can be assigned by a factory to other persons also. Unfortunately, if a company is having in financial crisis, then that factory should not sell the physical property, but patents, if that factory is having patent, the factory can assign the IPR's intellectual properties to others to overcome the financial crisis. So similarly, as like our physical property, intellectual property can be assigned. Secondly, intellectual property can be sold for financial benefit. One can sold the physical property, and after selling that property, the person which is sold loses its rights, and the person which receives that property or purchases that property, he or she can get the right of the intellectual property associated with that. Now, thirdly, intellectual property can be gifted. As we gift a property to others, the intellectual property can be gifted, and naturally, the person who receives the gift can enjoy the benefits associated with that intellectual property. So, intellectual property is treated as like a physical property. It can be assigned, it can be sold, or it can be gifted. So, it's important thing for filing a patent or creating an intellectual property. We can take benefit, financial benefit from the intellectual properties. Now, what happens if someone do duplication of that product, someone copied that material, it comes under the definition of the infringement. As like in our physical property, the word is used as a encroachment, but in intellectual property case, it is known as the infringement. Then let us see what is infringement. Infringement is unauthorized use, duplication of product, or sale of duplicate material, which is causing the financial loss of that original product or original company. It is known as the infringement, and it's a wrong thing, it's a punishable thing, it's a crime. So one cannot do the infringement in the IP. Let us see the three pictures I have seen here on the screen, shown here on the screen. One is OK, second is Ole, Colgate, and Bisleri. So all are the one of it is duplicate and one is original. Colgate is original, Colgate is duplicate. Bisleri is only original and Bisleri is duplicate. These are looking same, similar, but these are not same. This is the different and duplication, and it is the infringement in the product. So infringement in the IPR is the punishable thing. Let us see one example. It was the fine to the Samsung company more than $1 billion in the international court because of the crucial features copied by the Samsung brand and marketed the product in the market by the Samsung brand from the Apple company. When Apple company found this and it found a court case in the international court, and Samsung company was fined more than $1 billion. So it's a punishable thing, and one cannot do the infringement in the IP case. Now, after seeing that, let us see who can file the patent application. Means patent application, who can file? It may be having question in your mind. Let us solve this question. The applicant himself, true or first investigator, can go to the patent office and can file the patent. Means if you have found an intellectual property or patent, you just approach, you can go to the patent office and you can file your patent, or you can file your patent through home also. Secondly, patent can be filed jointly. If some supervisor is working with research scholar, and they can apply patent jointly also. Thirdly, if you don't want to go to the patent office, you want to go to picnic station or any hill station, and you can assign a letter to a person, go to the patent office and then file your patent to assignee. So patent can be filed through assignee also without going away from the home. Now, patent can be filed through IPR agent. What are IPR agent? Patent office conducts examination. Those who have passed the examination of patent agent, then they can license for filing a patent to guide a person which is willing to file a patent. So IPR patent can be filed through authorized IPR agent, and this can be benefited to literate and illiterate persons also. So patent is the subject not only from the senior teacher, junior college teacher, vocational teacher, high school teachers, mechanic, farmers, but it is the subject of all citizens. Literate, maybe illiterate. Illiterate person can approach to the patent authorized agent and can explain his idea or her idea to the patent agent, and then patent agent can file the patent on his or her name. So anyone can file the patent. Now, unfortunately, if someone is dead before filing a patent, that patent can be filed by the legal representative of that dead person. So the patent is filed anyway. There is no any obstacle for filing a patent, but only thing is that we have to create a patent. Now, let us see some breaking news on the intellectual properties in this section. What are the breaking news? There is 80% fee reduction for applying the patents, whether in India or the abroad. So there is a reduction in the fees by the government government of India for the institute, those who want to file the patents in India or abroad. Secondly, the scholarships of the government, the scholarships have announced for the students, those who are willing to study the intellectual property laws in India. Now, there is a patent reforms. Registration process is made easy to have easy to file a patent by the government of India. Also, national intellectual properties are award are announced by the government of India and academic institute to the academic institutes to promote the more and more filing the patents. And for the proud thing, I would like to share with you that the IIT Madras faculties, researchers and students have filed more than 184 patents in the year, only 1 year 2020, which was the pandemic year, and they get benefit. They have used that benefit of the pandemic, and they have filed more than 184 patents during this pandemic, and especially 19 patents were filed related to COVID-19. How to cure the equipments to cure the COVID-19, they have filed, and they are having 90 inventions of their filed on the COVID. So it's a congratulable thing for the institute for having the big success or huge filing of the patent. Now, intellectual property in humanities stream means in science faculty, the equipments they can search on the chemical reactions, or they are working on the equipments, various equipment. They can file the patent easily. But there may be a question in your mind that if the teacher is from humanities stream, then how she or he can create intellectual property? Let us see one by one in this section. Let us see two groups are intellectual properties. One is the industrial property and second is the copyright and other related rights. So from the first section, geographical indications. From the second section, writing, musical work, dramatic, audiovisual, painting, sculptures, photographics, architectural work, sound recording, performance, musician, artist, broadcast. All these are sections are applicable for the teacher who is from humanities stream. Let us go one by one to see the things. This is the geographical indication processing. Means a teacher from arts faculty can file geographical indication as a intellectual property. Means as our organizing committee was saying that Yeola is famous for the Paithani. So that Paithani can be registered under the geographical indications by your college because it's from your area. So the process of filing is that just filing the application, just advertisement in GI journal by the patent office, then examination of that GI, then opposition. If there is opposition, that can be done by the others, and we have to give proper answer to that. Then acceptance of GI. Now the GI geographical indication of that patent side will be study or that Yeola study will be accepted and then entered in the GI register, and you get the certificate. So a teacher from the faculty, humanities faculty, social sciences can apply the geographical indication any product which is famous one in that area. So you can apply for the registration of the geographical indication. Secondly, we can write the articles in the journals. We can publish the books. We can write our all writings which are innovative writing for our teaching or other subject. They can be registered under the IPR. Secondly, you can make audio visual work for your syllabus or for any social change or any issue. If you talk or make your audio visual, that can be registered as the intellectual property IPR. You can make audio visuals, dramatic work for imparting your subject to the with audio visual that can be created an intellectual property on your name. Secondly, painting, drawing, or any models, if you create for your subject to learn that subject more easily, that can be made an intellectual property to you. And also, if you make some sculptures, for giving the knowledge to the students of any model of your educational model that can be used as a intellectual property, registered as intellectual property. If you do some photographic work of your subject, and it can be registered under intellectual property as your creation. So intellectual property of the photographic work which is having innovative one, that can be registered under the intellectual property. And if you design your lab, if you design your research section intellectually, then design work can be registered under the intellectual property. And also, if you perform audio visuals for your subject or any social issue, that can be registered under the intellectual property of your own. Also, if you performed on the broadcast like All India Radio, online air, any all radio channel or any TV channel, if you produce some videos, audios, and your subject on that, it can be registered under the intellectual property. So these are the various ways for applying for creating the intellectual property. Those teachers are from arts faculty, commerce faculty, and also there is a huge of scope to form patent to the science faculty. Now, let us see the benefits of the patent. After seeing all details about the patent, filing of patent, how to create intellectual property, let us see the benefits of the patents or registering IPRs. First benefit is that your inventions are protected by the law. Means protection of your invention is done by the law. It's first academic benefit, because no one can claim the same invention to the others. If the invention is claimed on your law, it is the first uh, benefit. Second, you can transform your basic knowledge into productive knowledge. If you have an innovative idea, then that innovative idea can be performed, can be converted into a useful technique, useful equipment, which is modern and innovative one. This is the new benefit. Thirdly, the author or of IPR and institute gets reputation. If you have patent, if your institute is having patent, then its reputation in the society also increases. Fourthly, IPR attract the potential buyers. Means to purchase your patent, to to purchase your IPR, the potential buyers can approach to you and they give you a very huge benefit, financial benefit to you. And most important is that the ranking of the institute increases when we file more and more patent. It's the benefit, academic benefit for the institute to improve our ranking. Now, in the last, let us see that there was advertised fill it, shut it, and forget it. It was the advertised by the Hero Honda CD100 engine, because it was the most fuel efficient engine at that time. At that time, the products were is Java, SD, Rajdoot, all available, but they are having very less mileage. At that time, Hero Honda designed the most fuel efficient engine and advertised it as fit it, shut it, and forget it. Forget it. Similarly, we can say that we have to think innovative ideas innovatively in our mind. We have to draft or create the structure of that patent, and we don't forget it to file a patent. So all researchers, all teachers, all students may think on this innovative idea. They can create the patent, they can file a patent, and you don't forget to file a patent. So thank you for the organizing committee for inviting me. The session is open for the discussion. Those who are having some discussion, wish to discuss, I would like to discuss with them. Thank you, sir.
धनवटे सर आवाज येतोय तुमचा. धनवटे सर आवाज येतोय.
Hello. Hello. Am I audible, sir? This is Dhanraj Goswami, alumni of this college. First of all, I would like to thanks to all my professor to organize this wonderful webinar. Also, I would like to thanks to Dr. Betkar sir for giving this wonderful session. My simple question to sir, actually sir given very good presentation in that whatever the visual presentation, basically it is very good and make communication quicker and that simpler one. Sir, my simple question is that is any age limit for filing the patent or is any qualification for the same?
Thank you, Dr. Ganesh, alumni of this college, and you have joined here and you are in touch with this college. So thank you, very nice question. I am very happy to answer your question. Is that there is no any age limit, no any language limit, no any qualification for filing a patent. Each person can apply the patent, and no age limit for filing a patent. So it is an innovative thing. So one can file patent at any stage of age.
Okay, thank you, sir.
Karnataka. Dr. Vijay is an education officer, government of Himachal Pradesh. our Dr. Prof. From Bacchav, Dr. Kumarswami Singh, Assistant Professor, Department of Physics. From Patiala, Dr. Vijay Lakshmi from Madurai, and our special thanks to Honorable Dr. Anurag President, and Sri Deepak Gaikwad, Sri Gurudev Shikshan Prakar Mandal, Yeola for their motivation.
Thank you, sir. Thank you.
Thank our principal, Dr. T.V. Goswami, for his support. I wish to thank the Professor Ajay Tribhuwan, IQAC Coordinator, and Co-convener Dr. S.V. Dhanwate and his S.C. Pande, who daily work hard make this event successful. A special thanks to the teaching and non-teaching staff for their immediate support and coordination. Our heartfelt thanks to the participants and students for active participation. Thank you very much.
Thank you, sir. Thank you, and congratulations from Yamuna Kone, sir, from Karnataka. Thank you, sir.
Thank you, ma'am.
Thank you. Thank you, sir. Thank you, Arunani Committee, Honorable Principal Goswami, sir. Thank you, sir.